And so because of these new facts, you then sent a text to your current counsel that you wanted new counsel today. It's not gonna happen. They are. Ms. Perkins,
Yes.
stay on the line. We're gonna put you into a breakout room with probation intake.
Okay, thank you.
Thank you. It does call the case of the people versus Angel Wilson.
Assistant Public Defender Natalie Pate on behalf of Miss Wilson. Your Honor, to my understanding, she is not here yet today. I have been in contact with her. She did text me this morning saying she was running late and would probably be here around 9:30. For the record, I would respectfully request the court to consider either passing the matter or for an adjournment.
Why is she late?
She did not provide an explanation, but she did text me at 8:33 saying she was late and would probably be here at 9.
Pass the matter.
Thank you, Your Honor.
Are you ready for the trial?
I'm ready to proceed. Your Honor, my client does want to make a request of the court.
Wants to make a request of the court. Okay, go for it. Is it?
Put my appearance on the record. Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Arznowski. I woke up to a message from my client this morning requesting new counsel. I did send a message to the prosecutor when I got that message at 7:30 this morning. He does want to retain a private attorney.
Assistant Prosecuting Attorney Morgan Burrows on behalf of the people, all my witnesses and both victims are present and we are ready to proceed today.
When did you make this decision? Come up to the podium. Up to the podium.
I've been considering this and I just learned new facts that I thought are relevant enough for me to
Just learned what?
new facts.
New facts about what?
I just think I need a new attorney
You
to
learned new facts about what?
about this case.
And so what's that have to do with new counsel?
I would like to have a new counsel so we can look over those facts and everything that was and everything else.
So these new facts, when did you learn them?
Yesterday,
And so because of these new facts, you then sent a text to your current counsel that you wanted new counsel today.
yes.
Not gonna happen. It's date and time set for trial. This has been set for trial since the beginning of this month.
Right. It's just because the timing of the,
Have you shared these new facts with your current attorney?
oh, I learned it from them.
Pardon?
I learned it through them.
Yesterday?
In these past few days, yes.
Without disclosing any, what is he talking about?
I can't say, Your Honor. I've been part of this over the last week.
Well, let me ask you this, Ms. Perroni, do you have a position on his request?
Your Honor, I think a defendant's entitled to the counsel of his choice.
No, he's not.
If he doesn't want,
He's entitled to counsel.
if he doesn't want it to be the public defender's office, I have no objection to that.
Well, he would have had to make that request before the date of trial. So
I'm sorry, Your Honor, I'm not very experienced with these matters. I just wish I was more confident to proceed today.
Ms. Perroni, are you ready to proceed?
We are, Your Honor, but if he's not confident as my office has his counsel, I mean,
I don't think, not on the date and time of trial. He can't come in and just request new counsel. I think he's just trying to delay the matter. Quite frankly, I think he saw the witnesses show up and he decided that he was going to try to do something or knew they were going to show up.
Oh no, I did ask yesterday.
Sunday,
Yesterday evening.
the day before trial.
Unfortunately for me, I agree.
So you can have a seat.
Thank you.
Did you need to talk with him before trial?
you may have a moment, Your Honor.
Your Honor, for the record, there was an offer that was previously extended for the defendant to be discharged to count 1 and counts 2 and 3 would be dismissed.
For the record, is that offer still open?
Yes, it was open through today or through the beginning of the trial.
Thank you.
Court does call the case of the people versus Marco Karazan Kankowski.
Prosecuting Attorney Morgan Burroughs on behalf of the people.
I messed that up entirely.
Good morning, Assistant Public Defender Lauren Parent, Mr. Artis. We have come to resolution. Mr. Arzanowski is going to take the deal. Ms. Burrows will put on the record.
You want to restate that?
Yes, he's going to plead guilty or no contest to count 1. In exchange, counts 2 and 3 will be dismissed.
Correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Mark Zankowski.
Sir, it is this court's understanding you're going to plead no contest to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about a no contest plea I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for a no contest plea.
Potential civil liability.
So to that charge, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Fine.
Oh, I do have an advice of rights form.
You have one.
Does not the
You
document.
can
was-
give it to me.
Oh, yeah.
He signed it.
He did sign it in front of me, Your Honor.
You
We did.
signed an advice of rights form, sir.
Yes.
You have any questions regarding any of the rights contained on that form?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal over it.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 245469. Any objection to the court having reviewed that report?
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
The people are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 1. Counts 2 and 3 are dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter,
July 15th at 1 p.m.
July 15th, 2024. I'm sorry,
1 p.m.
1 p.m. As to the individual that you hit was whom? To you.
His father.
My father.
How old are you?
38.
Pardon?
I'm 38.
20,
38.
38? Your father. Great. Stop out on probation.
Thank you, Judge.
Jason,
You may be seated. Let me call another matter before I go back on. Court does call the case of People versus Angel Wilson.
Assistant Prosecuting Attorney Morgan Burroughs on behalf of the people. Would you like me to do the waiver, Your Honor?
Yes, please.
The people waive any potential conflict in the Honorable Court and the Public Defender's Office. We do not believe that any conflict is
Bridget Coons on behalf of Ms. Wilson. we likewise do not believe that a conflict of interest exists under court rule or state law. However, we do make this waiver out of abundance of caution and would waive any conflicts of interest.
And the court for its part, the court for its part also does not believe there's a conflict either under Michigan court rules or the cases decided there under to the extent a conflict exists. Given the waivers, the court will consent to hear the matters. All right. We're here on the bond violation. They're sentencing on the violation. Did you get the new report?
Yes, I did, Your Honor.
Is there anything you want to say before I?
Yes. Well, I'd like to start off. Miss Wilson is a 22-year-old. She's very apologetic to the court. For the initial violation, she was upfront and honest about the dirty blow. And she admitted when presented to her. There was a delay for the tether, which I believe is what you're referencing on the report. The day of court, she did, that was April 17th, she did go to community corrections, but because she had her child with her, community corrections do not allow kids within the facility. She did not have a babysitter at that time, and she wasn't able to get the tether fitted that day. On the 18th and 19th, likewise, she did not have a babysitter. She also does not have a valid license right now. So she is not able to drive herself to the facility. She relies on others to help her out with rides. So that is why she wasn't able to get the tether fitted until Monday. She was going to try to go on the weekend, but since the community corrections is closed on the weekend, she wasn't able to do that. She is working full-time, works at EHM Senior Solutions in Saline. She's been there for the last 4 years. She works, she also is enrolled inside school full-time, inside the nursing full program, and she's a full-time mother. She has no one to really help her with watching the kid during the day. So we'd be asked that she be allowed to continue on bond while this case is pending.
Anything from the people?
We leave it on the court's discretion.
The problem that I have, Ms. Wilson, is that on the 17th, you admitted to the violations. We set the sentencing out to today. In the interim, because there was a dirty blow, I had told you to report to community corrections to get on a scram tether immediately. That was on the 17th. It was not until Monday of this week that in the late afternoon on Monday that you put yourself onto a scram tether. I'm trying to figure out why.
Yeah.
I worked both.
What'd you say?
I worked Thursday and Friday, and yeah, I have my kid up until I go to work. And I also didn't know that my son couldn't go in there because I went over there after court. And
I understand that, but that was on Wednesday.
right. And then I worked Thursday and Friday, and they weren't open the weekend.
Did you work Monday?
No.
Then why did it take you till 3:50 on Monday to get there?
Drop my kid off to his dad, or he can come get his kid. That's why.
So she usually starts work at 3 p.m. until 11:30, and that's whenever the father of the child takes the child. Before then, she is usually watching the child.
Well, not watching.
Tell me how I know that you weren't drinking over the week. I mean, young lady,
I don't.
you're here on a drunk driving case. I put you on a sober line, right? The alleged blood alcohol content was 0.085. There was an accident. During the course of this, you're not blowing when you're supposed to, and then I have a dirty blow. I should have sent you to jail that day, and I didn't do it. And I didn't do it, giving you an opportunity to maybe show during this week that you could exist with a scram tether, not drink.
I'm confused with the last part you said, because I got the tether.
Oh, I know.
Oh.
5 days late. So I guess the record's clear. Between the time of the 17th to the time you got the tether, you didn't blow into a sober leg either.
Yeah, because the device locks. I didn't know if that was because
Because you were supposed to probably be on a scram.
Right.
And she did
That's
inform
all I
me
wanted
of
to
that.
show.
She did inform me of that yesterday when she tried to test on the sober link on the 18th. It gave her an error that it had to be reset.
And you did nothing.
Bring my kid in there, I can't.
But you did nothing. And then let me ask you this. Do you not take this seriously at all?
I do take it serious. Yeah, I'm busy. I'm a very busy person,
Okay,
and that's not an
we
excuse,
all are.
but it's kind of inconvenient for me. That doesn't mean that I'm not doing anything. I've been coming to court
This is
all.
all inconvenient. It's
not-
all inconvenient because you decided allegedly to drink, get into a car, and have an accident. That's all inconvenient. But if true, no one in this room is the cause of that inconvenience except you.
Right.
I think her youth plays an age inside this. She's only 22. This is her first criminal case.
I'm not even 22 yet. My birthday's Friday.
So she's 21. This
crazy.
is her first criminal case. I do think that going forward, she's going to take this very seriously. Whenever I talk to her,
But Ms. Coons, I appreciate that, but at what point? Because if you look at this report, I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Well, let's say 20 violations of basically, well, actually, it's not quite that many. It's about 15 violations of the program itself in terms of when she was supposed to blow. Then on the next one, she drank. Then, even after that, that was on April 5th. By the time we get the report, she reports back to court. I have on April 6th, she didn't test during the time frame. On the 7th, she didn't do any test. On the 8th, she didn't do any test. On the 10th, she did not test between 7 and 10 as scheduled. On the 12th, she didn't test. on 2 occasions for her testing that day between 7 and 10 a.m. and 2 to 5 p.m. She didn't test as scheduled. On the 13th, she didn't test between the 7 and 10 a.m. She did do a makeup test an hour and a half later. On the 13th, she didn't test between 10 and 1 p.m., 1 a.m. as scheduled. She tested at basically 2 o'clock in the morning on the 14th. She was negative. On the 14th, she then on that day still didn't test between 7 and 10 as she was required to do. And then basically 40 minutes later, after the testing window, she tested. And then later that day on the 2 to 5 test, she didn't test as scheduled. That was on the 14th. That's just this month. And then she appears before me on the 17th. I give her a break by not remanding her and tell her that she has to get a tether. And then I get here, I'm now and set this out to the 24th. And now I get here and she's too busy and it's inconvenient. Really.
I can understand the court's frustration.
Oh, I'm not frustrated. I'm just,
Yeah,
I don't get frustrated.
yeah. Well, she does have the tether on, so it would negate any further missed test, Your Honor. If she's able to continue on to bench.
So I'm just supposed to say, don't follow anything I told you to do.
Absolutely.
Just go on your merry way.
No, absolutely not. But when we spoke, she did state that she'd like to continue this case. She'd like to stay out in bond. She's able and willing to comply with all further court orders.
How do I know that?
I've been coming to court all year. I haven't missed a court date.
Yeah, you're right. You haven't missed a court date. You've missed a lot of tests. You miss going to community corrections. You went there when it was convenient for you. Young lady, that's not how this works.
I mean, I didn't have a choice. I can't bring my kid in there.
I get the 17th. You needed to find a way to make an arrangement on the 18th and 19th. You didn't do it. In fact, so that we're also clear on the 19th. On the 18th, community corrections talked to you that day. And you told them that you would report to them on the 19th.
Yes, because I thought I could, but I couldn't.
That's a Friday. And you didn't report on the 19th. You didn't call to reschedule or offer to them, according to this report, any explanation for your not reporting. You just didn't show up. And then on Monday, even if I accept your rationale that you were working and that in terms of working, you couldn't make it, even if I accept that rationale, which I don't. Monday, you weren't working and you still didn't go until late, actually after the agent that's assigned to your case at community corrections had left. And you're lucky that somebody else there stepped in and put you on a scram tether. Because otherwise you'd be showing up today with no tether. And mind you, the person that did that did it after the agent that's assigned to your case had terminated you from community correction supervision because you weren't compliant. Anything else?
And further. Nothing further, Your Honor.
Lady, you're gonna have to learn to just pay attention. When court tells you to do something, you're gonna have to do it. This isn't all about you. Everybody has busy lives. And I can appreciate it when I see people try. What I see in this report is somebody that's not trying. That somebody is putting other priorities ahead of what your obligation to this court is and what your obligation to this case is. And again, allegedly, you made the decision to drink. You made the decision to get into that car. You made the decision to drive. You made the decision to have that accident. It's a sentence of the court. Defendant remanded to the Washtenaw County Jail to serve 5 days for the violations to date. Mr. Allen, you may take her. Where are we, folks, on this?
We have.
I did receive the email this morning, or the message this morning. So.
Yes, I did let him know about the videos and then I just received them after 11 o'clock last night, opened them early this morning. We do have all of our witnesses today. It's my understanding that Mr. Hall would be objecting to admission of the videos. As a result of that, I would be requesting an adjournment so that he has adequate time to review them with his client and we would be able to use them at the next available bench trial date. I do want to note for the record that I did previously request all media associated with this case and was told that we had everything. So at this point, I'm not exactly sure where the gap was between that request and us receiving these surveillance videos. But at this point, I did not receive them until after 11 p.m. last night.
Your Honor, I received them at 8:30 this morning. Once Sister Counsel told me that they were in my inbox. And according to the police report, they were downloaded on January 24th of 2023. So they
Downloaded to.
police report just says they were downloaded. I'm not sure if it was to evidence.com or where it was downloaded to. That would be my assumption. And this case has been going on for nearly 15 months. So I would also object to the adjournment.
Your Honor, I checked evidence.com yesterday. I had 4 videos, actually, or 2 videos, I believe. I did not have the surveillance video yet.
And these, the description that the court got was that they're ring videos of, what are these videos? Yes. Ma'am, you can have a seat. No, you can sit right there. Okay, it's okay. They have to stand, but.
They're surveillance videos of the victim's home.
From where? No, I mean, I guess I'm trying to figure out.
It's surveillance videos, ring videos, which the ring systems are operated by the victim, equipped to his home, and include video of the alleged conduct by the defendant.
And those are the only videos in this case.
There's body cam and that was already submitted and uploaded into evidence.com, which was the video that I had available to me prior to 11 p.m. yesterday.
That's what I'm trying to figure out. What I'm trying to figure out is, Mr. Hall, when you reference something in the police report that says the video was downloaded, are we talking that video or are we talking other video?
It says David emailed me, here's surveillance videos of his front and backyard.
Got it.
I downloaded them on my computer.
Okay.
My understanding, Your Honor, is that they were downloaded to the internal Pittsfield public safety server, but not uploaded into evidence.com. I don't know what the gap was when I asked for all media associated with this case, why they were not uploaded.
Did we ask why that happened, or
I have not had an opportunity to hear back from them as to why that did not happen.
And you viewed the video.
Briefly. I had viewed the original video, which is body cam of the video on a computer.
Say that again.
So
The
during
other videos you've seen and viewed those.
body cam video, yes.
Right. This video is the one that you're saying you just saw this briefly.
Yes. The ring videos, they're much clearer and
They're clear.
yes. Those HD cameras now.
Yes. I have like 8 of them. And your grounds for objecting to the adjournment is solely because of length of time as opposed to.
Well, that and well, yes, and this case there was a plea offered and entered into at some point, and then that during the pre-plea version, that plea was pulled, and it continued on the trial, and a resolution was never reached.
I don't think that's an accurate statement of the record at all. Plus, we don't do pre-plea diversion in this court.
So I don't know what that is.
Maybe it was just a regular diversion.
There was no diversion in this whatsoever.
Yeah, I can help. This was a case where Patricia Reiser had offered, if she was to complete a mental health assessment and recommended recommendations of the therapist, along with do not violate the state law for 3 months and no contact with the brother for 3 months, that the case would be dismissed. My client did, or Miss Julian did do everything required under that. However, after it was completed, the plea was essentially pulled. She was no longer able to do that.
Your Honor, we have been over this multiple times. There was no note of that offer whatsoever made.
Well, I understand that, but
It also wasn't discussed with the victim whatsoever.
well, that may be somebody else's issue. So
And after,
was that offer given?
Your Honor, I have not been able to confirm either way, but what I do know is we had went on to additional negotiations afterward where another offer was formally recommended, offered and discussed, and we had agreed on it.
No.
Your Honor,
If the offer, so
Patricia Reiser, in the case, me and Morgan Barroso were on a Teams chat. She did confirm that the offer was there, and that was the offer on I think it was the second final settlement date.
And Miss Julian also did the psych evaluation. She completed it, and a report was produced.
And I do have that report available. I can print it off if you'd like.
That was not my understanding of the communication with Ms. Reiser.
okay, so hold on a second, folks. If I guess, was there, Ms. Kuhn, something to your understanding or anybody's understanding that if that offer was made, that as to a reason why it was pulled?
Because the victim did not agree to that.
And
Was
then-
the reasoning that was given.
And there was a change in the APA.
Yeah, and
There was a what?
Change from Patricia Reiser to Morgan Barroso.
Yeah, it wasn't that the victim didn't agree to it. The victim was never consulted about any resolution whatsoever, which he is entitled to because he claimed his victim rights under the Crime Victim Rights Act.
But that's not my client's responsibility to make.
Well, okay, I get that. I hear all of that, but I mean, I guess the problem that I have outside of the alleged victim their approval or their whatever, at some point, Ms. Julian is told to do something. She's told to do something that is sort of the ultimate resolution. That being, the case would be dismissed if you do these things. It's not, if you do these things, we'll give you a misdemeanor or something along those lines, that you still have to plead to something. For her, it goes away. And so then so from my understanding, and folks can correct me if I'm wrong, she does those things.
Correct.
At that point, then, I guess, the victim is contacted, the alleged victim is contacted, doesn't agree. And then and so then that offer doesn't happen. There's something wholly wrong with that whole scenario.
Your Honor, my understanding is not that the victim was contacted, it was that there was no documentation of that offer whatsoever. And the victim
Well,
was.
but Ms. Barroso, that's not my issue. My issue is that there was an agreement to do something. Defendant does it. Now, if on that side, what you needed to do wasn't done, that's a whole other thing. But I don't. Stands at recess.
All rise.
Or does call the case, People versus Misty Perkins.
The prosecuting attorney Morgan Burroughs, on behalf of the people, would you like to waive it now, Your Honor?
Yes, please.
The people waive any potential conflict between this honorable court and the public defender's office, so the people do not believe that such a conflict exists. The people make this waiver in avoidance of any doubt.
Good morning, Assistant Public Defender Lauren Kearney. The Public Defender's Office likewise does not believe the conflict exists among those.
The court for its part also does not believe that there is a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict exists, given the waivers, the court will consent to hear the matter. All right, what are we doing on Perkins?
Mayor, we have come to a resolution. Ms. Perkins is going to plead as charged, or plead no contest as charged under a prosecutor.
That is correct.
Ms. Perkins, can you state your name, please?
Misty Perkins.
All right. Please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name again for the record.
Misty Perkins.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of malicious use of a telecommunication service. That is a misdemeanor punishable by up to 6 months incarceration and $1,000 fine plus court costs. You understand that?
No contest.
Yes, sir.
Pleading no contest to that charge. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yeah, I'm basically pleading guilty without explaining everything, right?
Guess that's one way of looking at it. But basically what's going to happen is I'm going to read the police report, take those factual allegations as true to see whether or not a crime was committed. You understand that?
Yeah.
You understand that it means that you're not further desirous or wanting to contest this charge.
Can you say that again? Sorry, I didn't hear you.
It means that you're not further wanting to contest this charge.
Yes, sir.
All right. You understand also that for the purposes of sentencing, the court will treat you the same as though you had pled guilty.
Yes.
All right. Do you have any other questions regarding a no contest plea?
No, sir.
You said no, correct?
No. Yeah, right, correct. No, I don't have no questions.
All right. Basis for the no contest plea? To the charge of malicious use of a telecommunication service, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Correct. Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, ma'am?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
no,
Anybody threaten you or coerce you?
No.
I didn't hear that.
no, sir. Sorry, my baby. I have little ones at home and don't nobody want to help me. Sorry.
Okay, it's all right. You're doing this voluntarily
Yes,
and of your own free will.
yes.
The court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-10573. Any objection to the court having reviewed that report? Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this charge. Counsel, have I complied with the court?
The people are satisfied. Satisfied, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 24th at 9 a.m.
July 24th, 2024, 9 a.m. Bond with its conditions will continue. Thank you.